Hello, it's nice to see you again. Last time I introduced estate planning and wills and mentioned that if your assets exceed $100,000, you cannot receive disability benefits. So I explained that if an inheritance of more than $100,000 is passed on to a child with a disability, that child will not be able to receive disability benefits. The solution to this problem is a trust. So today I will take some time to introduce trusts. Once again, I want to emphasize that this information is general and does not constitute professional, legal, or financial advice. Before I explain trusts, there was a question related to disability benefits. What happens to disability benefits when a child with a disability turns 65? They are converted to the old age security pension, and if the child with a disability has a low income, they will receive the Guaranteed Income Supplement, or GIS. The total amount will likely be higher than the disability benefits received before turning 65. Usually, if there is a high income, it affects the amount of GIS, but I want to emphasize again that the RDSP does not affect GIS. Now, I will explain trusts as part of estate planning. First, let me explain what a trust is. A trust is established by a settlor, which in this case would be the parents. The settlor transfers property rights to the trustee, and the beneficiary, who would be the child with a disability, receives the benefit. This refers to a legal relationship in which the trustee manages those property rights for the benefit of the beneficiary. This means that while the trustee is the nominal owner of the property, the actual owner is the child with a disability. Therefore, the trustee manages the assets for the child with a disability and makes expenditures on their behalf. As I briefly mentioned earlier, the reason for establishing a trust like this is a bit more special because the beneficiary is a child with a disability. First, it is because the child with a disability cannot manage assets on their own. Second, it is to ensure that disability benefits can continue to be received. It is also set up to support the child with a disability while they are alive. Another reason is to protect the child with a disability from being harmed by people with bad intentions. It is also to manage assets more effectively. Asset management refers to things like financial management and tax reporting. It is also to protect the assets in case the child with a disability gets divorced or has creditors. Lastly, you need to specify in the trust all these aspects so that any remaining inheritance after the child with a disability passes away can be passed on to someone else. Next, I will talk about the types of trusts. There are 4 main types. The first is called a living trust, which is used when a person transfers their assets to their child while they are still alive. The second is called a testamentary trust or posthumous trust. This refers to a trust that becomes effective from the time the person who wrote the will passes away. The trusts we are discussing now mainly refer to testamentary trusts or posthumous trusts. If you are interested in living trusts, I recommend that you consult separately with an expert who is well versed in living trusts. Next, there are also non-discretionary trusts and discretionary trusts. I will explain these 2 types of trusts in the next slide. First, in a non-discretionary trust, trustee does not have full authority over asset management, and the beneficiary has a certain degree of control over the trust assets. Therefore, if the beneficiary requests a payment from the trust funds, the trustee has no discretion and must pay the requested amount. So, with this non-discretionary trust, only up to $200,000 of the funds in the trust are exempt from being counted as assets. If the amount exceeds that, the excess is considered as assets. Therefore, if there is more than $300,000 in a non-discretionary trust, only up to $200,000 is exempt from being counted as assets, which means that more than $100,000 will be considered as assets. As a result, you will not be able to receive disability benefits. Please keep this in mind. However, if you get approval from the relevant government department, it is possible to adjust the exemption limit. Next, I will talk about discretionary trusts. These are called discretionary trusts, or sometimes Henson trusts. Most families with a person with a disability set up this type of discretionary trust in their will. This means that the trustee has the discretion to decide how to use the trust funds for the beneficiary. Funds in a discretionary trust are not considered as assets. In other words, No matter how much money is in the discretionary trust, it does not affect the eligibility for disability benefits at all. That is why most families with a person with a disability choose to set up a discretionary trust. This allows the beneficiary, that is, the child with a disability, to continue receiving disability support payments, while also being able to receive additional support from the trust funds at the discretion of the trustee. Therefore, it is very important to carefully select the trustee. Now, let's talk about how trust distributions impact on disability benefits. Discretionary trust assets are not recognized as assets, but the trust distributions received monthly are considered unearned income. Because of this, unearned income usually has a direct one-to-one impact on disability benefits. However, if you receive funds from a discretionary trust as a trust distribution for the following purposes, they are not considered unearned income. This means you can continue to receive disability benefits. The purposes are as follows: funds used for medical assistive devices, caregiver expenses, education or training costs, home modifications and repairs for the disabled, and expenses to promote the beneficiary's independent living are all included. This last one is actually very important, and in the past, there was an $8,000 annual limit on this final category. However, since December 1st, 2015, this restriction has been removed. So as long as the expenses are necessary to promote the beneficiary's independent living, even if they receive a large amount from the trust, it is not considered unearned income, so it does not affect their disability benefits. That's what this means. Now, when designing a trust, the most important thing is to first clarify what you want. That is, what the person setting up the trust wants. In this case, it's the parents. And it's also important to clearly understand what the beneficiary, the child with a disability, wants. Another crucial point is selecting the trustee. You must appoint at least one trustee. The number of trustees you appoint can vary depending on each individual's circumstances. Now, I will talk about the duties of a trustee. The trustee's primary responsibility is to manage the trust assets. This includes investing the trust assets, handling accounting, reporting income and taxes, and making government reports. The trustee also decides when and how to use the trust funds for the beneficiary. They are also responsible for the maintenance and upkeep of real estate. Additionally, they handle all records related to the trust. The trustee is also obligated to report to the beneficiary about the trust. Now let me talk about what kind of person would be a good choice for a trustee. I have repeatedly emphasized the importance of selecting the right trustee. You also need to consider whether to appoint one trustee, two, or even more. In addition, you must decide who will be the successor trustee in case the current trustee is suddenly unable to manage the trust. Naturally, the trustee should be someone who knows the child with a disability well and can meet their needs. In addition, you should consider factors such as age and place of residence. If the trustee is about the same age as the parents, they are likely to pass away around the same time, so it's better to choose someone younger than the parents and preferably someone who lives near the child with a disability. If you live in Canada but appoint a sibling who lives in Korea as the trustee, communication will be very difficult, both in terms of staying in touch and making decisions. Another important point is that the trustee should have knowledge about disability support benefits so they can manage the trust in a way that does not affect the disability allowances the child receives. Also, it is beneficial to have someone with expertise, such as in accounting or finance, so you might consider appointing 2 or 3 trustees, one or more with professional expertise, and another who knows your child well. You could also entrust the management to a trust company. However, usually when you use a trust company, the fees are quite high, so you need to have a certain amount of assets for it to be worthwhile. Usually, banks require trust companies to accept at least $700,000. At a place called Dan City, from what I found out in the past, you need to have at least $500,000 for them to manage your trust funds. However, since the people at these banks or trust companies do not know your child with a disability well, it is essential to appoint someone who understands your child's needs as a co-trustee. Next, I'd like to talk about a few things you should consider when setting up a trust. First, make sure to designate an ultimate beneficiary. In other words, you need to decide who will inherit the remaining assets as an estate after your child with a disability passes away. Second, and this is a bit more complicated, you should consider excluding the principle of impartiality. First, let me explain what the principle of impartiality means. Legally, when there are multiple beneficiaries of a trust, for example, the current beneficiary, who is the child with a disability, and when there is a remainder beneficiary who will receive the remaining assets after the child with a disability passes away, the legal principle is that the trustee must not act in a way that favors or disadvantages either party. Therefore, if this principle is applied, you cannot use the assets more favorably for the child with a disability, which is why I am suggesting that you exclude this principle. So if you exclude this principle, meaning if you specify in the trust to exclude such a provision, you can use more of the trust assets for the child with a disability rather than for the remainder beneficiary. The third point is that you need to examine whether there is a possibility of a conflict of interest. This means that you need to be careful in cases where, if the trust beneficiary passes away, in other words, if the child with a disability dies, the remaining assets go to the trustee. In other words, if the trustee is set to receive the remaining assets after the disabled child passes away, it would be in their interest to spend as little as possible for the benefit of the disabled child. That's why you need to be careful to prevent such conflicts of interest from arising. One way to address this issue is to appoint a co-trustee. Another situation to consider is the extent of the trustee's investment authority. Should you allow only deposits or also permit stock investments or limit it to bond investments? You need to set various parameters regarding the trustee's investment authority. And as I mentioned briefly earlier, you must ensure that there is no vacancy in the trustee position. You need to designate a successor trustee in case the current trustee is unable to manage the trust. And since the trustee does not work for free, although if it's a sibling, that might be possible, you need to determine the amount of compensation for the trustee. If there is no mention of this in the trust, the law states that the trustee can claim up to 0.4% of the total trust assets. So, it would be best to clearly specify this part. Lastly, there is advice to consider appointing a protector. This refers to the authority to oversee the trustee, and if the trust is not being managed properly, to remove the trustee from their position. So, what makes a good estate plan? A trust is not necessarily the only option. There are various types of assets that do not affect disability benefits. For example, assets under $100,000 do not impact disability benefits. Also, the person's primary residence, the vehicle owned by the person with a disability, the RDSP, and amounts from an RRSP that have been converted to an RDSP do not affect disability benefits either. So if the trust assets are not that substantial and these aspects are already sufficiently met, there may be no need to create a trust. Therefore, a good estate planning strategy involves not only trusts, but also making use of the various methods mentioned above. Now, I will talk about what kind of lawyer you should look for when setting up a trust. Not all lawyers are well versed in wills and trusts. However, since many lawyers do handle wills and trusts, a lot of them could be considered as potential candidates. But just because a lawyer is knowledgeable about wills and trusts does not mean they are also familiar with issues related to disabilities. Therefore, it is important to find a lawyer who is knowledgeable about both the field of disabilities and the areas of wills and trusts. So, to help you find such a lawyer, let me share 2 questions you should ask when you meet with a lawyer. The first question is, how many disability trusts have you created for the last 5 years? This means you should ask whether they have set up disability trusts for children with disabilities in the past 5 years, and if so, how many they have handled. The second question is to ask them to explain how, under current law, the will and trust you create will have an impact. By asking these kinds of questions, you can check how well the lawyer understands disability support benefits and other disability-related matters. So today I talked to you about trusts, including last time's discussion on wills. And today's topic of trusts, I've covered the two most important things you need for estate planning. As I mentioned last time, I recommend that you review the workshop materials again and set up your will and trust as soon as possible at an appropriate time. All right, that's all for today. I'll see you next time with another topic. Thank you for watching until now.